Great. We still have time to file for an ALR, but like I said, the clock is ticking. Filing for an ALR is of the utmost importance for two reasons. First, it gives you the opportunity to potentially save your driver's license. Second, it gives us an opportunity to completely review your criminal case by testing it on the civil side. Basically, by filing for an ALR, we can review all the facts of the case from the get-go. When we meet face-to-face, we will talk more about what the Department of Public Safety has to prove in an ALR setting and what we can do to attempt to prevent them from meeting their burden and suspending your license. Typically, in a criminal case, police reports and other evidence the state will try to use against you are not available to your attorney until a trial date has been set. However, once the ALR has been filed, all that information becomes immediately available to your attorney. For example, if you took a breathalyzer test, we can subpoena the maintenance records on that particular breathalyzer machine to see if it was maintained and calibrated according to standards. If it wasn't, we can use that information to attempt to have the results of the test thrown out. We can also investigate the reasons and procedures related to your initial traffic stop and look for discrepancies and violations of the officer's probable cause for stopping you in the first place. We can even put the arresting officer on the stand in your civil case to see what kind of witness he'd be in the criminal case. These are just a few examples of what our attorneys are able to do in the ALR hearing. Having this information immediately available gives you a huge advantage in determining the viability of your criminal case. Okay, let's move on to the criminal case. Again, I will ask you a series of questions that are important for me to understand in order to evaluate your case. One of the key pieces of evidence the state will attempt to use against you are the results of your breath test. As stated earlier, the threshold for intoxication in the state of Texas is 0.08 blood alcohol content. However, many people refuse to provide a breath specimen, which is great for your criminal case. You have a constitutional right against self-incrimination. The law says the state cannot use the fact that you raised a constitutional right against you in a criminal proceeding. Although not providing a breath sample is not so good for you in your civil ALR hearing, it is great in your criminal case. Because without it, there is no breath evidence that can be used by the state to try to criminally convict you. Answer the two questions to the right, and we'll continue with your evaluation.